All right, our next case is Cedarbrook Residential, and we've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Good afternoon. May it please the court. I'm Adam Dorr with Robinson Bradshaw, here with my colleague Demi Bastian, and we represent the North Carolina Department of Health and Human Services, the appellant in this matter. I'd like to reserve 5 minutes for rebuttal, if I may. In this case, the plaintiffs asked the court to hold that an entity regulated by the state can file a tort claim based on the theory that a state agency was negligent in interpreting and enforcing state law against it. The court should not accept the invitation to create such a claim. The plaintiffs in this case are Cedarbrook Residential Center and its owner, Fred Leonard. Cedarbrook operates a facility in Nebo, North Carolina, that houses adults, many of whom have mental illnesses, and it operates as an adult care home under North Carolina law. Adult care homes are residences for people who may require 24-hour supervision and help with daily living. Most adult care homes provide services for elderly residents who can't live alone, commonly called nursing homes. General Assembly mandates the Department of Health and Human Services to regulate these homes to protect their residents. That appears throughout the statutes. Section 131D19 says that it is the intent of the General Assembly to promote the interests and well-being of the residents in adult care homes. Section 131D21 provides a declaration of residents' rights, and 131D26 makes clear that the Department of Health and Human Services shall be responsible for the enforcement of the provisions of this article. The department was acting under this statutory mandate when it undertook the actions that Cedarbrook is attempting to challenge in this case. It was conducting inspections and assessing penalties based on the results of its inspection of Cedarbrook, all with the goal of protecting the people who resided there.
I think the argument your friend is making, as I understand it, is that it's like a foundational principle of tort law that we, as a society, we expect people to act reasonably with ordinary care to avoid causing foreseeable harm to others. And so if, for example, someone walked by this residential care home and knocked over let's say a bucket with some flammable liquids and starts a fire and burns down the building, that if that person didn't act reasonably and it was negligent, then you'll have to make them whole. And all that's happening here is we're applying that same burden to state regulators by saying you just can't act negligently and carrying that out, because like the fire that burns down the building, state regulators wield tremendous power and can destroy a business through their negligent acts. And so it's really just holding the state and its regulators to the same standard of care that exists for everybody, and that's what the State Tort Claims Act was intended to do. So to me, that's the heart of the case, is figuring out why is that wrong, that general policy idea about what the State Tort Claims Act is doing here.
Sure, and Judge Issa, certainly Cedarbrook's argument. So to take your example of a bucket of flammable liquid that gets knocked over and ignites a building, if that happened during an inspection of Cedarbrook and it happened as the result of a negligence of a state employee, we'd have no issue or question that that falls within the scope of the Tort Claims Act. But this is a different case, because Cedarbrook's claim, so let's stick with the bucket of flammable liquid. If the Department of Health and Human Services came and said, we don't think it's safe for you to have a bucket of flammable liquid next to your building here. This is not safe for the residents of this facility. We're going to fine you for not having safe conditions. That takes it outside the realm of an ordinary negligence claim, and it puts it into a place where it's inappropriate for a regulated entity to try and challenge that regulated decision through this lens of tort law.
Now, are you arguing this is a sovereign immunity, or are you arguing this is a public duty defense?
These areas overlap to a pretty large degree. So we argue that it's sovereign immunity and that the department has sovereign immunity against the claims that Cedarbrook is attempting to bring against it. And where public duty comes into play is that there's only a limited waiver of the sovereign immunity within the Tort Claims Act. And so the state has agreed to be sued in situations where a private person might otherwise be liable.
And in Ray, our Supreme Court, in talking about Chapter 143, 299.1, the intent to limit public duties, Supreme Court said, by the plain language of the statute, the public duty doctrine is a defense only if the injury alleged is a result of a law enforcement officer's negligent failure to protect the plaintiff for actions of others or an act of God, or a state officer employees involved negligent failure to perform a health or safety inspection required by the state. That's what the Supreme Court said in Ray when they were talking about whether or not it was a major change, but that's what they said that the statute did. Is that correct?
Yes, that's correct, Judge Arrowwood.
And what part of this falls within that language? That I'm on to public duty now.
Understood, Your Honor. So the Supreme Court also said in Ray that the amendment was clarifying and that it left prior law intact. And so the prior law, including cases like Stone, that's the fire,
But they said it only did this, too, didn't they? I'm
yes,
reading
they
you
did.
from
The decision
from the
is not
case
a model
itself.
of clarity. I will concede that. And we would submit, Your Honor, that it doesn't make sense to have a public duty doctrine that only applies when there is no regulation at all, rather than regulation that doesn't comply with some statutory standard. And when the General Assembly amended the law to implement that point on the public duty doctrine, there was no contemplation of a potential claim for regulating as opposed to not regulating, because all of the plaintiffs in the cases that had been occurring to date were all involving people who had been injured when the state didn't do its job to protect them. So they were people who worked in a poultry processing plant where there were no smoke detectors and there was a fire. The court held that the public duty doctrine applied. They were residents in a correctional facility, again, a fire where inmates were killed and injured. And again, the court held that the public duty didn't apply in that situation because it was a situation where there was a special duty owed to those people. But in all of those cases, those are suits by victims who are injured as a result of the state's failure to protect them. And that's the context in which that legislative amendment is made.
Well, but isn't it up to the legislature to include what your clients are saying they shouldn't be charged with as opposed to us?
I will concede that it would certainly be an easier case if the legislature had said that there cannot be a claim against the state for negligence when it's regulating the party that is charged with enforcing state law against. However, that limitation already exists in state law because there's the principle of sovereign immunity and the limited waiver of sovereign immunity in the Tort Claims Act. And that waiver does not extend to the kind of regulatory conduct that Cedarbrook is attempting to challenge in this case.
Well, that was where I was headed, so your friend is going to argue that the only purpose of that reference to there being a similar action against some private party is because the state, by default, has sovereign immunity. So I think what your friend is going to argue is this: you can imagine how you could have a negligence claim against a regulator, because the duty would be to act as a reasonably prudent regulator under the circumstances. And the fact that there are no private actors that are engaging, that would have that duty because only the state is regulating it, is irrelevant. The point is, if you apply the law, the basic negligence principles to this conduct, and then you said, hypothetically, is this a private party, could you be liable? And the answer is yes, then you can pursue the action. So why should we not adopt that? I mean, you could certainly say that interpretation falls squarely into the plain language of the State Tort Claims Act. So Why should we not follow that?
I have multiple answers to that question. The first is that the private person standard is indicating the General Assembly's intent to put state employees on the same standing as fellow citizens. So if the plaintiff, in this case, Mr. Leonard, had come to a meeting at the offices of the Department of Health and Human Services, and the floor is wet, and he slips and falls and hurts himself, the state cannot say that it has sovereign immunity in that context, because it's acting in the same way that a private person might. Any landlord, anyone who holds a facility open to the public, has an obligation to keep their premises safe. Same thing with a department employee driving a car, right? If the person doesn't drive with a reasonable care, like a private person would, the state can be held liable if they're negligent and causes an accident. None of that indicates, however, that the state or the General Assembly intended to waive sovereign immunity for regulatory actions that it charged state departments with making. Instead, when it comes to the mechanisms that business owners can use to challenge regulation, the General Assembly created a whole statutory scheme for that purpose. It set up in the same statutes that Cedarbrook was enforcing, that the department was enforcing against Cedarbrook and that Cedarbrook is challenging, it sets up a contested case hearing in front of the Office of Administrative Hearings with an administrative law judge. And we submit that that's the proper forum, rather than looking at these things through a tort law lens where the normal tort standards don't really apply. And I take your point, Judge Dietz, that you can try and look at things from the standpoint of a reasonable regulator, but our argument is that the General Assembly committed the decision of what's appropriate in a regulatory context to specialized administrative law judges.
And what's the remedies that are available under the Administrative Procedures Act?
So under the Administrative Procedures Act, there can be a challenge, the penalties can be reversed, and there's a limited provision for attorney's fees. But that is where the General Assembly saw fit to end it. And our argument is that the General Assembly acted purposefully to set up a structure that would empower its agencies to take steps to protect the people of North Carolina by regulating and enforcing laws designed to protect them without the fear of liability in a tort claims action. It set up, instead, a separate action that's designed for a uniform system. That's the language in 150B for the Office of Administrative Hearings. And in a uniform system of lawmaking and adjudicatory proceedings to protect business owners. That's the remedy here.
But can't you see the argument that your friend is going to make is that, well, but what the APA is really doing, what's happening in the administrative process, is that that's addressing two things, and one is when there's fact disputes that need to be resolved about whether, in fact, someone's in violation of some law, and then second, when there's a legal dispute about whether, in fact, the state's correct in its application of these regulatory provisions. But what the administrative process is not suited to address is when the state regulators breach some duty of care, and that can lead to much greater harms. And so that's precisely why we have the Industrial Commission to hear these. We don't want these to come into the court system, but we've got a place where you can go if you say that state regulators act negligently. And it may be that it was just an understanding that state regulators are not angels. They're just like everyone else, and they can breach some duty of care, and it can cause very serious harm to someone else, and we want to hold them accountable. I mean, it seems like you can look, and I think the commission, that's what they were seeing, is they were just sort of going through and saying, this checks all the boxes, and so we don't need to be concerned if the legislature doesn't want these types of suits against regulators. They'll clarify the statute.
Yeah, and I think that the term you used with respect to the commission of checking the boxes is exactly what the commission did. It looked at the fact that Cedarbrook had filed the Industrial Commission affidavit and said that that was sufficient to waive sovereign immunity. And our position is no, you need to look to the actual substance of the allegations if you're going to deal with the sovereign immunity issue. You can't hold that it's waived simply because someone filed paperwork with the Industrial Commission. And if you think about some of the specific allegations of Cedarbrook's complaint, some of the issues here. So for example, there was a patient, or excuse me, a resident of Cedarbrook who the department found had not been monitored properly and been allowed to wander away from the facility and was found 4 miles away. Cedarbrook disputed that in the Office of Administrative Hearings. That's appropriate. But the way that the General Assembly struck the balance between protecting citizens and ensuring that owners of facilities would have a remedy was that they could challenge it in the Office of Administrative Hearings, but they did not go so far as to waive sovereign immunity and create a duty enforceable in tort.
Could we talk a moment about how your argument is impacted by the case, the Nanny's Corner Daycare Center case, versus your client, actually, where I believe our court said that the Tort Claims Act would be the place that something like this should be brought?
Yes, Your Honor. The Nanny's Corner case is a little bit of a tricky case. It's gone up to the Court of Appeals twice. So the decision that you're referring to is an appeal from dismissal of constitutional claims. So it's not an appeal from the Industrial Commission. And there was no substantive discussion of sovereign immunity in that case. There's no analysis of a potential tort claim there in any substantive way.
But the court does say that the Tort Claims Act explicitly grants to the North Carolina tort claims against state agencies.
Yes, it does. And the court does that on the way to holding that the availability of that claim, which is a little theoretical in that context because it was already time barred.
Well, they said that because it had that claim, that the constitutional claim, you couldn't pursue a constitutional claim, is what the court said. But the court found that, that's the language I believe I'm quoting accurately.
Right. In other words, that had to be part of a legal holding, right? Because in order to dismiss the constitutional claim and say there's no adequate remedy, the court must have decided as a legal matter that that remedy existed. So are we now bound by that determination? You know, it was a previous panel of the Court of Appeals that said that. So is that, in your view, binding on us now?
In my view, no, it is not. Our position is that in that case, yes, the court considered that as part of its ruling, but it did not have the benefit of any briefing or argument on any of the issues that are before the court today, and that the theoretical availability of a claim in the Industrial Commission is far too thin a basis for this court to hold that a claim like Cedarbrook's can proceed counter to 70 years of precedent under the Tort Claims Act. If these claims were permitted, they would be abundant. Every time that there was a claim in the Industrial Commission, in the Office of Administrative Hearings, the business owner could easily characterize that as negligence and turn around and file such a claim. In the Industrial Commission as a tort claim, the fact that that has not happened throughout the cases of this court and the Supreme Court is a clear indication that that claim simply doesn't exist. And every time,
I'm sorry. Go ahead.
I was just going to say that in the situations where people have tried to make claims akin to this court has refused to go along with it, and it has made a clear distinction between a claim for negligence and a claim for intentional regulatory action. So there's a case involving the state bar, where a disbarred lawyer attempts to sue the state bar for enforcing sanctions against him for unauthorized practice of law. And the court says, that's not a negligence claim. That's an intentional action by the state bar. You can't bring that claim in the Industrial Commission. And there are 3 or 4 other cases that we cite in our briefs to that same effect.
Well, I want to go back now to your
course.
Contention that we're not bound. I'm trying to think back through the civil penalty opinion that talks about one panel not overruling another. And I don't recall there being a carve-out for, well, it wasn't properly briefed there, and so they couldn't have had the benefit of it. I just don't recall that carve-out. Can you point me to where that carve-out is in in-ray civil penalty?
I cannot. I can provide another basis to distinguish the Nanny's Corner matter, however, which is that Nanny's Corner involved a situation where a county Department of Social Services had determined that somebody who operated a child care center had taken some sort of inappropriate action with children. And so when the claim against the state, my client, the Department of Health and Human Services in that case, was that the state effectively adopted or accepted that county determination without doing its own investigation. So
they were negligent.
perhaps they were, but that case was not a challenge to a regulatory decision by the Department of Health and Human Services in the same way that this case is. If you go through the complaint that Cedarbrook filed in this action, every single item in the complaint is that the Department of Health and Human Services committed negligence, was erroneous when it entered a suspension of admissions, when it applied these penalties. Those are things that the state mandates that the department do when it's faced with these violations. So you can have a dispute about some of the complicated issues in this case, such as if there are residents engaged in sexual activity, is it more important to respect their autonomy, or does the state have a duty to try and ensure that they're practicing some form of safe sex and not exposing themselves to disease?
But isn't this an argument about whether your client was doing the right thing or what was required by the statute? Isn't this an argument on the merits, not on the argument of whether or not the claim can be brought at all?
I don't raise that claim to argue the merits. I raise it to show that Cedarbrook's claim is a challenge to the regulatory actions rather than the form of negligence action that the state waived sovereign immunity to allow claims against it for. And I just think that's the critical point. If the state did not waive sovereign immunity for negligence claims like Cedarbrook's, that's the end of the case, and their claim needs to be dismissed. And I think it's very clear that in the past 70 years, there have been a lot of creative lawyers. There have been a lot of entities regulated by the state that have been very displeased with the state's regulatory actions. But there has never been a case where the state has found that, where the court, this court or the Supreme Court, have found that the state regulators owed a duty to the party that it was regulating that could be enforced in tort in a claim in the Industrial Commission. The closest, I will agree, is Nanny's Corner, but even it does not go that far. And given the Supreme Court's express command to construe the Tort Claims Act narrowly, because it's applying to sovereign immunity and derogation of common law, I don't believe there's any way for this court to adopt this kind of claim consistent with the past history of case law. I'll also submit that if it were to recognize such a claim, that this court and the Industrial Commission would be flooded with copycat cases every time that a business owner is displeased with a state regulatory action, because all that's required to assert a claim like Cedarbrook's is to catalog the regulatory actions against it, and then at the end say, the state owed us a duty and it violated that duty.
But isn't the remedy that's to go to the legislature and ask them to change the statute to specifically set that forth?
I would put it differently, Your Honor, and say that the legislature has already made that decision in carving out a limited waiver under the Tort Claims Act that doesn't encompass claims like this. And that if Cedarbrook wishes to be able to bring those kinds of claims, or other regulated entities want the General Assembly to draw a different line between trying to protect state citizens on the one hand and protecting business owners, people regulated by the state on the other, that they could pass a change to the Tort Claims Act that would allow directly a claim for challenging regulatory actions with damages, which the state has never permitted and does not permit under the Administrative Procedure Act. If the state wanted to create that claim, the legislature thought it was appropriate, it would do so expressly. And we shouldn't read it into the Tort Claims Act by implication through the back door, especially in a way that's so inconsistent with so much prior law.
As I understand your argument, you're saying that the sovereign immunity is the rule, the Tort Claims Act is the exception, and the burden is on the claimant to show that the claim fits within that exception, and it's narrow. Is that a fair summary of what you're saying?
That's absolutely correct, Judge Dyson.
So, nothing else appearing, sovereign immunity applies.
Yes, sovereign immunity is a foundational principle of North Carolina law, and unless the state has consented to be sued, as it did in a limited way in the Tort Claims Act, sovereign immunity bars suit.
So, in terms of holding the state accountable the same as a private party, using the language of the statute, do regulators have a duty to regulate in a certain way?
The duty on regulators is the duty imposed by the General Assembly as set forth in the statutes that it has created. So in the context of adult care homes, the legislature has created this whole structure with a Residents' Bill of Rights and specific enforcement provisions and specific penalties. That's what a regulator needs to follow. And our view is that it would be inappropriate to try and layer a tort-based duty on top of that and would in fact impair the regulator's ability to carry out their statutory duties.
Well, let's say, do you consider a regulator to be a form of law enforcement officer?
It's a law enforcement adjacent, I guess I would say.
So there are situations where law enforcement officers' conduct can be subject to a state tort claims act
Yes.
if they act negligently or willfully or wantonly.
In certain circumstances, although the public duty doctrine generally applies in most of those.
So where does the line cross between a regulator, quote, having an idea of the length of the extent of their power that is not given to them? What are you claiming, that the Administrative Procedure Act would be the only remedy that an affected party could have for someone who overstepped their bounds in regulation?
And I see that I'm out of time. If I may answer your question, I do want to reserve a little time
Please.
for rebuttal. Yes, I do believe that the Administrative Procedure Act is the remedy that the state has established and that it's exclusive. And I think that the reason that that exists is because it's important to the state to accomplish the legislative goals set forth in the regulatory statutes to protect the citizens of North Carolina. And the state never waived sovereign immunity in a way that would allow second guessing of those regulatory decisions in the context of a tort claim, because that could deter regulators from doing what they need to do to protect the citizens of the state.
All right, thank you, counsel.
Thank you.
We'll hear from the appellee.
May it please the court, I'm Joseph Ponzi with Brooks Pierce, counsel for the plaintiffs' appellees, Cedarbrook Residential Center, and Fred Leonard. And Mr. Leonard is with us in the court today. The circumstances of this case may be unusual, but the claim is simple. The adult care licensure section negligently undertook inspections and licensure actions against Cedarbrook, an adult care home in western North Carolina, damaging Cedarbrook and its owner as a result. Cedarbrook initiated a Tort Claims Act action in the Industrial Commission by filing a complaint with significant factual allegations, establishing the claim and invoking a waiver of sovereign immunity. The question for this court, as DHHS has put it, is whether under the Tort Claims Act a state agency is held to a standard of care, of reasonable care, and the exercise of regulatory authority, And the plain language of the Tort Claims Act answers it directly. Agencies of the state are liable for their negligence, for the negligence of their employees acting within the scope of their employment.
Can you tell me what is the department's duty to your client in this case?
Well, negligence is universal, or the standards of care are universal. In any active course of conduct, the people undertaking that course of conduct owe a duty of reasonable care. In terms of the regulatory framework that they're operating within, they do have a duty to implement and administer their regulations faithfully. That's underlying some of the claims that we have brought forward, and that's where, in terms of where those violations occur, our relief for the regulatory violations are with the APA, are with the OAH, and the claims are violations of the APA. But that doesn't excuse the negligence of the agency. Because they have undertaken a positive course of conduct, they owe a duty of reasonable care. That's black letter negligence law.
And you're contending that's common law. That's not something you say is established in the statute. Is that right?
Well, it's both. It is common law, but the waiver of sovereign immunity is found in the statute. The Tort Claims Act specifically says the Industrial Commission is constituted a court for the purpose of hearing and passing on all tort claims made against all state agencies. So that is the waiver of sovereign immunity that brings to bear these standards of care against state agencies and their employees in their course of conduct, including in the course of regulating regulated entities.
Yeah, but your friend from the state says that it's actually more complicated because what the plain language of the Tort Claims Act essentially does is say, examine whether there is any private person who could ever have this same duty. And if not, then there's no waiver of sovereign immunity. And the argument is, and there are no private people that regulate others and ensure they comply with state law. That's the job of the state. So you're carving out this entire category of claims that even if there could theoretically be a negligence action, can never be brought. So what's your response to that?
And there is that clause in the Tort Claims Act that a state would be negligent if a private person were negligent. And the courts have examined that and talked about what that means. And in particular in Patrick, it notes that the language of the Act merely means that the state may be liable if, under the circumstances, a private person is liable. It does not suggest that the state can only be liable if a private person would have the authority to undertake that same conduct. It merely means that it's the same law of negligence that applies.
Let me ask you this. Do you think there's a certain amount of discretion that's attributed to a regulator in whether to enforce something or not? Is there a range of discretion?
Certainly, Your Honor. The regulators do have discretion, and the courts have also said that whether the Tort Claims Act applies to their conduct is not a matter of whether their regulatory activity was discretionary or not. Doesn't
Could a
matter.
private party go in and do what they did to your client?
Absolutely not. No, only a regulator could go in, and only a regulator has the authority to go in and take licensure action against the client. And these were extreme licensure actions over a long period of time that caused significant harm.
So going back to Judge Deep's question, if a private party cannot do what the state can do, how can a regulator be held to being negligent under that standard?
Because the standard means that it's the same law of negligence that applies. And
So it's not that a private party could necessarily do that same act.
that's exactly right. And if you look at Huskett v. Department of Corrections, that involved the application of sentencing guidelines by the Department of Corrections. And the court said this is exactly the kind of claim that the Torts Claim Act was enacted to cover. A private party can't apply sentencing guidelines to send an inmate to prison. That's never been how the courts have looked at and interpreted that language. It just means that the same law of negligence applies.
So I take it your interpretation to make this a workable standard is you imagine, hypothetically, if this was a private person, could they then be held liable? Which is, in your argument, is so essentially saying if there's no sovereign immunity, if otherwise you could bring this, and so it doesn't matter that only the state ever does this thing, because hypothetically, someone else could have that duty, and if so, could they be held liable for negligence? And then you say, if yes, then sovereign immunity waiver applies, you go to the commission. That's your argument?
That's exactly right, Your Honor. And that dovetails with the argument by DHHS that because these are regulatory actions, the Torts Claim Act can't apply.
What is your burden for the commission? The fact that your complaint may state a claim to survive a motion to dismiss does not necessarily mean that you can prove a case, can you?
No, it's not automatic. We have the burden to prove negligence.
And you admitted earlier that a regulator has a degree of discretion on whether and how to interpret a statute
Certainly, Your Honor.
and how to enforce it.
That's right. And that will be part of our burden, to overcome that degree of discretion, to show that they went so far beyond that they failed to exercise reasonable care.
Where's the limitation then, with this exception of the State Tort Claims Act as a exception to sovereign immunity? Wouldn't the exception swallow the rule if we were to agree with you?
Well, I don't believe so, Your Honor. I mean, the exception is that is negligence. It's a standard of reasonable care.
No, the general rule is the state cannot be sued. That's the general rule.
That's correct.
Okay, the State Tort Claims Act is the exception to the rule.
Right.
So if we were to allow these claims against a regulator, why wouldn't the exception swallow the rule?
Well, there's still the burden of showing negligence. And the rule is limited on the face of the Tort Claims Act to circumstances where a state employee is acting within the scope of their employment and authority. And the DHHS has raised this sort of parade of horribles. The Tort Claims Act has been in existence for 70 years, and that hasn't happened. And to the extent that that were to occur, it would be for the General Assembly to address.
But
Well,
you've already admitted that a private party cannot do what the regulator did.
That's correct.
So where is your standard of negligence if a private party cannot do it?
Well, the standard just goes back to black letter law. It's reasonable care that an ordinary person would exercise under the circumstances. So we have to hear, and this, if we were to go back to the Industrial Commission, we would have to put ourselves in the position of an ordinary person exercising that regulatory authority under the circumstances. And did they exercise reasonable care? That's the standard that we have to show DHHS violated in the course of those inspections.
Well, let's talk about the public duty doctrine, a couple of minutes here. Would your claims that you bring here have been barred by the public duty doctrine prior to the 2008 amendments to the statute for the General Assembly?
They may have, Your Honor, and DHHS would certainly have a stronger argument that they were, because there is some, in terms of undertaking an inspection, there is some public protection purpose to it. Now,
Well, then how do you get past the Ray discussion about this being a clarifying amendment as opposed to new law?
that discussion in Ray was a discussion about whether the statute should apply retroactively. That discussion in Ray dealt with when it applies. And in fact, Ray said, as you noted in your earlier questioning, Ray specifically stated that the public duty doctrine only applies in those two limited circumstances, and in all other cases, the public duty doctrine is unavailable to the state as a defense. The title of the public duty doctrine, as the Industrial Commission's order notes, is a limit use of public duty doctrine as an affirmative defense. It limits it to two specific circumstances, neither of which are our case. This is not a negligent failure to inspect a facility. This is the negligent inspection and regulatory action against the facility. And here, too, this is why the public duty doctrine shouldn't apply regardless. Because they are taking an active course of conduct against a specific party, against a regulated entity, they owe a duty of care in the course of that conduct. And Your Honors, I would turn back to this question of regulatory action. that DHHS argues that regulatory actions against those subject to their authority is not within the Tort Claims Act, and that we can't show any cases that show otherwise. Well, first of all, there is no such carve-out in the Tort Claims Act. It says that the Industrial Commission is constituted court for hearing and passing upon tort claims against all agencies of the state. It does not go on to say, except when they're exercising their primary function. But in the plain language of that act is reaffirmed by the holding in Zimmer, which specifies that the Tort Claims Act does not create an exception for negligent performance of duties involving discretion. And you see this time after time in multiple cases in Husketh v. Department of Corrections, where it is a regulatory body exercising regulatory authority against a person who they are exercising it against. And the court said that's exactly the kind of claim the Tort Claims Act covers. You see that in the septic permitting cases like Crump and Watts, both of which involved the negligent issuance of a septic permit. And it was the party who was harmed who was issued that permit who brought suit, and those were successful and those were cognizable in the Industrial Commission under the Tort Claims Act. And then, of course, as you raised earlier, Nanny's Corner, which basically involves the same or very similar circumstances here. Negligent licensure action against a facility subject to the state's, to the agency's regulatory authority. And you asked about the implication of Nanny's Corner. And Nanny's Corner, as you noted, decided that the quorum claim for constitutional due process violation was dismissed precisely because the daycare had an adequate state remedy in the form of the Industrial Commission through the Tort Claims Act. Had it come out otherwise, were this case to come out otherwise, what this court would be doing would be effectively bringing to life a quorum claim for constitutional violations. And it makes no sense for that to be the process for a regulated entity to get relief when the General Assembly has spoken to this issue. They have created a claim for negligence and a waiver of sovereign immunity for these kinds of circumstances. There would be no reason to create that back door, and that would be the implication of finding that sovereign immunity weren't waived here. But underlying all of DHHS's arguments is this suggestion that it would be a bad thing to hold regulators to a standard of reasonable care in the exercise of their authority. And that's exactly wrong. We want state regulators to behave reasonably, especially given the weight of authority they can bring to bear against small businesses like Cedarbrook.
And again, if you or this court, if we held that this claim can go forward, if we're wrong about that, the legislature can fix it. The state has unlimited resources, so the risk if we get it wrong here seems relatively low. I mean, if you prove negligence, I think we'll all sleep at night if your client receives, is made whole for having that business destroyed by the negligence of state regulators. And if the state says, no, we want to be immune from that, they can amend the Tort Claims Act to clarify that. I assume that's sort of the core of your argument.
I wouldn't say that's the core of my argument, but it's certainly the state has that ability.
I guess I should say the rebuttal to this policy argument they're making about this potential flood of similar cases.
And I would also note that there is a cap on liability. The legislature has saw fit to put the cap on liability at $1 million, and that's collectively per any incident. And I would also note that our damages exceed $1 million, so we don't even have the ability to be made whole. But we can recover at least some of that, or at least have the opportunity to try to recover at least some of that in the Industrial Commission, which is the body that was created by the legislature to handle exactly these kinds of claims.
What would, if we were to agree with you, what would happen to the ability of the agency to itself to enforce its own internal policies over its employees?
Your Honor, if the court agrees with my argument, that just means that the agency owes a duty of reasonable care to the people they regulate. And I'd also note that most regulatory action is not an existential threat to businesses.
Is that duty not owed to the public generally? To protect the public from acts of a regulated entity?
Well,
So why do they have a duty to you? Why is that duty to the public?
the duty is to Cedarbrook because they were investigating Cedarbrook. And this is where the public duty doctrine does come into play, because if you're talking about duties to the public generally, law enforcement officers have a duty to the public generally to protect them from others. And that's where the public duty doctrine says this is too broad and we're going to cut off liability here. But here, they weren't taking an active course of conduct against the public. They were taking an active course of conduct against Cedarbrook. And that's why the duty is owed to Cedarbrook in this instance. It is protective of the public, these investigations and actions, these regulatory actions. But they're directed, in this particular instance, at one facility.
But you have a vulnerable population. You do agree with that?
Absolutely.
And a lot of times they cannot speak for themselves.
Absolutely, Your Honor.
And the only way that their treatment can be brought up is a lot of times through the enforcement action by the agency that is regulating under your license, correct?
There are other resources available. I wouldn't go that far. Often, many of them have guardians who are advocates for them. They're nonprofit groups. But they are part of the purpose of the regulations is to ensure that residents are protected. And here, I would say, Your Honor, that because we had a vulnerable population, the state needed to exercise higher care, and they actually exercised far less. And I can give you a very discrete example. A resident who the state identified as a violation of Cedarbrook because of her hoarding behaviors. She hoarded. The state concluded that there was a violation and mandated that Cedarbrook either clean her room or discharge the resident, kick her out. Now consider how unreasonable that is. Hoarding is a mental illness defined by the very behavior that the state said we had to prevent. This resident was under the care of a mental health professional. She had been a long-term resident of Cedarbrook and had been stable for a long time. And the state acknowledged that kicking out this resident or forcing her to clean her room would risk destabilizing or even hospitalizing the resident. And they said do it anyway.
That's normally an argument that a teenager makes, isn't it? About cleaning the room?
Well, Your Honor, unfortunately, this resident was older than that, and it was, she had a serious mental illness. And it was defined by the very behavior that the state was saying we had to prevent. And they came in without any mental health professionals on their staff and made these decisions for themselves, and it caused real harm both to the residents and concerning harm to the residents. But what's really at issue here in this case is the harm that resulted to Cedarbrook. Unfortunately, as you note, the residents really don't have any recourse. There's not any monetary claim for them to bring or any advocate who would be able to bring it. But here, it also caused harm to Cedarbrook, and it was premised, much of their regulatory actions were premised on their own misunderstanding of this vulnerable population that we had. And Your Honor, this would be perhaps a good opportunity to raise other instances of, sort of clear instances of state, what we would say, failure to exercise reasonable care. Many of those instances were factual findings or legal conclusions that were unsupported, if not demonstrably wrong, decisions which could only have been made by a failure to exercise reasonable care. One would be a failure to discharge. The state found that the Cedarbrook had violated the regulations by failing to discharge aggressive residents. However, in depositions and in discovery, the regulators could not identify a single resident who should have been discharged. And this is actually a good example also, Your Honor, of an instance where at the time the statements of deficiencies, basically their charging documents were issued at the beginning of the survey process. We looked at those documents and couldn't understand what we were being charged with. What are the findings of fact, and what are the bases for these violations that you're alleging?
But counsel, that goes to your burden if you get over the hurdle. That doesn't knock the hurdle down, does it?
It certainly doesn't, but it provides context for how these damages occurred. We did receive a preliminary injunction in OAH from the administrative law judge, but we received it 8 months after the suspension of admissions was issued because we didn't know, we couldn't understand what the claims were, and we had to build a record first. And so we went into discovery and we built that record, and then we went to the judge and we said, we have a likelihood of success on the merits. A stay is warranted. You should enjoin this suspension of admissions, and the judge agreed, and he issued the stay. But in the meantime, we were under that suspension of admissions the entire time, meaning we could not admit new residents, and so our revenues declined and declined. It basically leaves the facility to die on the vine. And part of it here
What
is,
was the conclusion of the 150B administrative procedure challenge, other than the injunction? Or is it still pending?
it's not pending, Your Honor. On the morning of trial, DHHS withdrew all of the allegations. Every licensing action it took against us as part of a settlement that was read into the record that day. They withdrew everything. That was the conclusion. And that followed, that came on the heels of the preliminary injunction, I think 3 months after the preliminary injunction that was issued by the ALJ. And so we followed that with this action. And because of the significant amount of harm that resulted, again, the suspension of admissions is detrimental to these facilities. The resident population declined by half. Cedarbrook's costs and lost revenue and increased cost in excess of $500,000, and it actually blocked a planned sale of the facility that would have gone through but for these licensure actions by DHHS.
If I'm a truck driver and I've got a rig financed and I am unlawfully charged with driving under the influence, and they take my license for a year, I go through court, and I go through district court, and go to superior court, and I'm acquitted. Do I have a right to go against DMV for depriving me of my license for a year? And I lost my truck through foreclosure.
Well, Your Honor, I think you may have a claim that you could bring in the Industrial Commission. I don't think it would get very far if the DMV is exercising a ministerial function and revoking your license. And so I think the standard.
I'm acquitted. I was acquitted.
That's true. But if the DMV is the standard there again is reasonable care. Is this the exercise of reasonable care by an ordinary person? But there too, most regulatory actions aren't existential threats to businesses. There are many. Most are small, and we're not going. Parties aren't going to run into the Industrial Commission at every wrong. Things get worked out. The state has a policy in OAH of settlement, and issues get resolved. Usually, they get resolved without nearly shutting down a business, and that's why we're here today. It's not because Cedarbrook lost $20,000. It's because they lost over $1 million and nearly lost the business as a result. So over 70 years of the Tort Claims Act, this has not been a problem. It hasn't been flooded with these claims, and there's nothing about this one that would indicate that that's going to change.
If I couldn't open my restaurant because of a regulatory action of a pandemic, and I go bankrupt and cannot operate my food, do I have a claim against the state? Because they issued an order telling me that I could not open my restaurant?
Well, Your Honor, if it's an action by a state agency and acting within the scope of their employment, again, it's a possibility that you might have a Tort Claims Act claim if it's available on the face of the Tort Claims Act, but you'd have an awfully hard time.
The answer is yes, if those state regulators or decision makers don't act reasonably, right? It's not a hard standard because we all have it in everything else we do. Apparently, the only people that don't have to act reasonably to avoid foreseeable harm to others in the view of the state are the people working for the state, and they can be negligent and ruin people's businesses and not be accountable. And your point is, actually, we think the State Tort Claims Act says, no, you answer for it here. That's your argument.
That's exactly right. Thank you, Judge Dietz. And it is, we want the state regulators to act reasonably and be held to a standard of reasonable care. And DHHS tries to sweep all of this away. as regulatory action, but regulatory action to the licensed business is personal and it is consequential. And it's an exercise of authority by the state against it. And we want the regulators to exercise that authority reasonably, and that is the policy of the state as set by the Tort Claims Act. And for those reasons, the court should affirm the Industrial Commission's order. I'm happy to take any more questions you may have.
Thank you, Counsel.
Thank you.
Any brief rebuttal?
Thank you. Briefly, on the point of the courts have not been previously flooded, that's because this claim has never before been recognized. If it were to be recognized, we believe that there would be plenty of cases. And of course, we want state regulators to act reasonably. But that doesn't mean that the General Assembly has ever waived sovereign immunity to permit these claims against them. I think Judge Tyson's point with the truck driver or the restaurant illustrates it well. Those would be disappointed business owners, and if this claim was a reality, all they would have to do to sue the state is say that the state acted unreasonably or didn't follow due care in making decisions that it's trying to take to protect the public. That's not the law. And these sorts of claims fit very poorly into the lens of a tort claim. So,
I want to ask you a question on rebuttal.
of course,
About duty. We learn in law school duty, breach, causation, damages. Those are the elements of the tort.
yes.
Where is there a duty to the regulated entity?
There is not one. The duty, as is made clear by the General Assembly, is to protect the citizens of the state and the residents of the adult care homes. And so the state has purposefully made a policy decision that the owner of the adult care home can pursue a remedy in the in the Office of Administrative Hearings if it disagrees with the regulatory action, but it has never authorized a tort claim in that circumstance. And honestly, a tort claim, yes, you can try and apply a concept of general reasonableness to any decision, but it fits very poorly in this context. So one of the issues that Cedarbrook takes issue with is that the department, when it conducted interviews of residents, it based some decision-making on the self-reported information from Cedarbrook residents. So that's an interesting question. It's a good one for an administrative law judge to resolve, but I don't think there's a reasonableness tort law question in determining whether it's appropriate on the one hand for the Department of Health and Human Services to interview residents and rely on their reports, or on the other hand, to say, as Cedarbrook does, that you shouldn't rely on what they have to say because some of these people have mental illnesses and they're not reliable narrators.
Is it
That's not a
reasonable for-
tort lens that works. Excuse me.
Is it
Judge.
reasonable for a regulator to impose their personal religious or ethical beliefs on an issue about if you need to stop someone from having sex or we'll close you down?
We would dispute the sort of underlying premise of that question as applied to Cedarbrook, but
Well, that was one of the allegations are there of that
Correct.
general. I may not have done it precisely, but that's generally what the allegation was.
yes,
as
you were
I
very
recall.
close to the allegation. And we would say that if the regulator acts inappropriately, that's a situation where the remedy is in the Office of Administrative Hearings, as Cedarbrook pursued, as they got an injunction, and as far as, the case being settled and dropped, that's the purpose of regulation, is to promote changes in behavior and bring things up to compliance. And if things change in the meantime or the circumstances are different, then yes, it makes sense for things to be resolved. What does not make sense is then to proceed on to the next step of trying to enforce some sort of tort-based duty.
So how do you do with the collateral damage from that delay or from that over-regulation for the person affected?
I think that the only answer to that lies with the General Assembly. They've chosen to provide a limited set of remedies, and once those limited set of remedies are exhausted, that's that's what they've chosen to do, and you're back in the general rule, as you put it, of sovereign immunity. If I may, I would just like to close with one last point related to a decision that Your Honor, Judge Arrowood issued just this week. So there was another case against the Department of Health and Human Services. It involved a woman who wandered away from an adult care facility. This is Tang. She was discovered, her body, 10 years later by someone who was hunting in the woods. And so her family filed a claim against the Department of Health and Human Services, and they said that the department was negligent because the facility wasn't monitoring the residents appropriately, and the department didn't act. And the decision held the department liable. If Cedarbrook's claim is also correct, that puts the department in an impossible position. If it doesn't act and a resident is injured, it can be liable in a Tort Claims Act. But if it does act, then the owner of the facility can say, you've regulated too aggressively. We don't want the costs of hiring extra staff to monitor these exits. This is totally inappropriate. And then they just label that as a negligence claim and file it in the Industrial Commission. And that's not consistent with the balance that the General Assembly has struck. The General Assembly has said, here are the limited remedies available to owners of these facilities. Beyond that, the state agencies charged with protecting the people of North Carolina need to have the flexibility to enforce regulations and enforce state law without fear of being sued in the Industrial Commission. And with that, unless there are further questions, I would thank the court for its attention and ask that the order of the Industrial Commission denying the defendant's motion to dismiss be reversed.
All right. Thank you, counsel. Thank you. All right, with that, we will adjourn, but we were going to stay up here on the bench. So I don't actually know if anyone, is there someone that's supposed to formally adjourn us?
All rise. This session of the North Carolina Court of Appeals is adjourned.
All right. Well, thank you. Well, just very briefly, I know we're running a little over time, but I want to give my colleagues up here the opportunity to make a few comments, and then if there are any questions that anyone has, you feel free to ask them, but also we're going to come out to a reception and stick around for a little while, so feel free to come up to us individually. But I do want to thank the officers for today for providing us with some security. We appreciate that. I want to recognize, I see our business court Judge Mike Robinson is here to watch the arguments. Thank you, Judge Robinson, for being here. And with that, I'm going to hand it over to my colleagues if either of you have any comments to make about the argument today.
Well, I would just say I thought, as students, you saw 4 excellent arguments from a fairly hot bench that you don't necessarily always see at the Court of Appeals, but these were interesting cases, and so we're certainly happy to be able to come and do these in the law schools around the state whenever we're invited, so we're pleased to be here.
I'd like to echo what Judge Arrowood said, and also I'd like to introduce one of my law clerks who is here today, Anna Cribb. Anna, if you would stand. And also one of your fellow students, Mary Claire, who was my intern last summer. Mary Claire. We know that there's a burden 2 hours from Wake Forest over to Raleigh that sometimes limits your abilities to have externship and internship opportunities during the regular course. And there is a summer externship opportunity through the youth advocacy that gives you a paid position for 12 weeks during the summer. So the deadline to apply for that is in January. And I know that with exams and trying to get home for Christmas, that deadline can easily pass. But I would encourage you to look at that, particularly the 1Ls, who will find it pretty difficult sometimes to find a paying position for the summer, and you end up volunteering or you end up doing it for class credit, which is fine as well. But I want to give the students an opportunity to ask us questions we cannot comment on the cases today, obviously, or the attorneys that are here, in case you had questions about something you saw today that you would like to be answered. And don't be bashful.
Hi, my name is Bryce. What was your individual tax to the bench?
I clerked at the Court of Appeals. I was the staff attorney and the head of the staff, and I was a commercial litigator in Charlotte for 26 years and was a Superior Court judge for a short period of time.
My path was through more of a transactions practice, which is unusual path to get to an appellate bench. A lot of the judges come through the trial bench, either as a district or superior court judge. But I had a transactions-oriented practice, taught law school for 35 years at Campbell. And so my path was a little different to get to the bench. All of our judges in North Carolina are elected. The appellate courts are statewide races. So that's, the path is through election, through a statewide election.
I'm from Virginia, so we do it different.
Yeah, your legislature appoints your judges, yes.
But yeah, nice. So I'm a graduate of this law school, and then I clerked for 2 federal judges and worked for a large law firm in D.C. called Covington & Burling, and then came back here to Wake Forest because my wife got a job here and joined a firm called it's now called Kilpatrick Townsend. The name's changed a bunch of times. So I was a partner there, and my entire career, all I did was appeals. So U.S. Supreme Court, all the federal courts, and the state courts. And so I was actually, the one exception to the you have to be elected to be a judge is if there's a vacancy, you can be appointed by the governor to fill the vacancy until the next election. So that's how I got to the court, was a judge retired. I took the spot and then ran in the next election. Unfortunately, didn't lose my job. The voters kept me around. So, so thank you for the question. Anything else? We probably have time for maybe one more question. Then I don't want to keep you all too long.